Good afternoon, everyone. Welcome to House Judiciary on May 27th, 2025. We will be reviewing H 105, Act relating to expanding the Youth Substance Awareness Safety Program. We'll have a walkthrough and witness testimony. And if our alleged counsel, Ben Navarowski, would join us. I can share this. Ouch.
Just being accurate. Good afternoon, everyone. Ben Novogrodsky from the Office of Legislative Counsel. Doing a run through of, I'll do the side by side. Probably be easiest for everybody to digest. So just bear with me one moment as I pull it up. So before the committee is a side by side of the House passed bill and the Senate proposal of amendment. So while this is a 17-page side by side, the vast majority of the changes are technical. And when I say technical, I mean they're updating internal cross-references because subsection A of this bill was replaced with the definition section. So it bumped everything down. So a lot of the changes you will see are sort of a result of the downstream effects of that. However, I will highlight sort of at the outset what I view as the big substantive change here, which is the addition of cannabis possession to the 7 VSA 656 to consolidate all the YSAS programs and the elimination of it as a delinquency, which is, again, what the House had decided to do with impaired driving. The Senate now added cannabis to that. And then an addition of some procedural additions here as well. You'll see that there's an addition of providing the option to review an automatic suspension that was imposed by the commissioner under Rule 75 of the Rules of Civil Procedure. And with that, also the addition of providing notice of that option in the notice of suspension that is provided to the person subject to this section. So that's a general overview of the changes. And now I'll go into the details unless there are any initial questions. Okay. So you will see here that in section 1, the title of the bill, 7 VSA 656, is amended in the Senate version to add possession of cannabis to the title. And then also the addition of a slew of definitions that were present in Title 23 that are now just being carried over. I believe there's one or two also that are also in Title 7 that are being cross-referenced here. So, for instance, alcohol has the same meaning as in Title 23, alcohol concentration, cannabis. Highway has the same meaning. Ignition interlocks device. Ignition interlock restricted driver's license, RDL, or a permutation thereof has the same meaning as the Title 23 definition. Law enforcement officer has the same meaning as enforcement officer in Title 23. License to operate a motor vehicle has the same meaning. Motor vehicle or vehicle has the same meaning as motor vehicle. Operate or attempts to operate has the same meaning. Operator, person. Privilege to operate, suspension or suspension of the person's operator's license, all have the same meaning as the Title 23 definition. So for the avoidance of doubt, there is no confusion if these statutes are ever litigated in court that there might be some difference that wasn't captured. This brings in all the same definitions and terms from the previous statutes that are either being rolled in to 7 VSA 656 or being repealed so that everything is treated the same. So any questions on the definitions?
Yes. One question. For the sake of good statutory writing, I'm curious if the the couple instances in here where we're saying, for example, on 7, law enforcement officer has the same meaning as enforcement officer. Should we just go in here and change law enforcement officer to enforcement officer so that they correctly mirror each other? 23 in here, you know what I mean?
An interesting tidbit is that law enforcement officer was what was used in the old version of 7 VSA 656, but it wasn't defined. And so now we're kind of closing the loop there because it was used in other portions of Title 23 and defined. So we're saying the enforcement officer in Title 23 is what law enforcement officer in Title 7 should be considered. So again, it's that consistency.
Yeah.
If you want to change the definition, I mean, but law enforcement officer is what's present in the statute now. And are you asking if we should change the other references in Title 23 to law enforcement officer as well?
Well, I meant more, I wasn't saying we should do anything. I just was trying to understand, like, there's a couple of places in here where the language that's in this title and the language of Title 23 are the same.
Right.
And we're just saying that the definition is the same.
Right.
There are a couple in here where the title is a little different, but we're saying that it is the same definition as Title 23. So while we have our hands in this, should we change the titles in this statute to reflect the titles in 23 so that they're all kind of mirroring each other?
That's really a policy choice, I suppose.
Okay. There's just a couple instances like that one, the suspension 14. There's a couple, one or two other ones. I don't know.
Yeah, I mean, my approach here, especially given the stage that we're in, is to not upset the apple cart.
Okay.
Or to upset it as little as possible. And so while you can do that, it just would require at this point
Another.
either that or a conference committee.
Okay, never mind.
It's a process piece.
Mhm.
Yeah.
Any questions on the definitions themselves or why certain ones are added, anything like that? Bless you.
Yeah, well time. Just wanted to understand, make sure I'm understanding that the definitions were added here as like the old belts and suspenders. Like we were always referring to these definitions, but we hadn't brought them over in our version.
Exactly.
Okay.
So just making sure that the loop is closed.
Gotcha. Thanks.
So if there are no other questions, I'll move on to the next portion. So you'll just see that what was subsection A is now referred to as subsection B. And you'll see subdivision C was replaced with the cannabis prohibition. So just as a refresher, it's prohibited that a person under the version of this bill who's 12 years of age or older and under 21 years of age shall not knowingly and unlawfully possess 1 ounce or less of cannabis, or 5 grams or less of hashish, or 2 mature cannabis plants or fewer, or 4 immature cannabis plants or fewer. And that language is lifted from 18 VSA 4230B and just brought into this statute. So the language of it hasn't changed at all. It's just now in one singular statute instead of really distributed between two. And what this also will do is that you'll see the delinquency aspect of this has also been repealed, similar to what this committee did with the impaired driving delinquency. So it's now all within the YSAS program. And if someone fails to enroll or complete, they'll be adjudicated in the Judicial Bureau for a civil violation. And you'll see here what was C, which was subdivision C is now subdivision D. And then what was D is now E. So again, just moving down to show how it flows. And then you'll see I've highlighted in subdivision 2, A through C here, which the equivalent is A through D. Again, that's just the downstream effect of moving these things around. So But just to remember, A through D are those possession, consumption, and procurement penalties that are all grouped together and have the same consequences. And this now includes possession of cannabis. The one that has the enhanced suspensions or fines is impaired driving. And again, you'll see here on, I guess we're on page 5 now, in the impaired driving penalties portion, again, updating the internal cross references. There was a slight change here where in the House version it said and shall serve a suspension. This is what imposes that automatic suspension for impaired driving. It was clarified a bit in the Senate to say that the Commissioner of Motor Vehicles shall suspend. So again, automatic suspension, just clarifying who the person is that's actually suspending it, because that informs the Rule 75 review procedure, because that requires a court filing basically to review the decision of a government official or agency. And there were some questions, is it the law enforcement officer that's suspending or who is it? So just clarifies that it's the DMV and the commissioner of DMV, and any Rule 75 review would go through that, with that agency being the named party. Any questions there? And again, you'll see a lot of the internal cross references that are being updated, and that's the bulk of these highlights here. I'll just quickly keep scrolling and I'll stop when there's a more substantive change. So you'll see here now, so we're now on page 10, and this is the issuance of the notice of suspension. Previously, and in the issuance of notice of violation. So again, the way it left the House is that only a person shall be cited for not more than one violation of subsection B. So they can't be cited for both possession and consumption. The law enforcement officer would have to choose. But what the Senate wanted to do is that oftentimes where maybe there's a presence of more than one drug, so maybe there's both cannabis and alcohol present, they would have to choose who the violation that the person cited for, but they wanted to ensure that any substance that's indicated is listed on the notice of violation, really for the YSAS program and diversion and the lawyers, so everybody knew sort of what the person was dealing with for rehabilitative concerns. Any questions? And then again, we'll see some more dandy internal cross-reference updates. You'll see here, though, in the notice of suspension, so we're now on page 11, the addition of new subdivision F. So in the notice of suspension, this is if someone is, accused of impaired driving, and they are given the notice of violation. They're given a notice of suspension, which says their suspension will go into effect on the 11th day after issuance. The notice has to contain a bunch of information for the person to be aware of. So again, what the effective date is, this is the duration, what the consequences of it are, and the Senate added the ability to review the imposition of the suspension pursuant to Rule 75 of the Vermont Rules of Civil Procedure. So the person will be aware when they get that notice that they have that option to review the automatic suspension on the document that they're handed. And then you'll see as we scroll down the substantive portion of that. So we're going down a couple of pages. So this is now on page 14, where previously a person who had been aggrieved by the decision of the diversion program. So let's say, for instance, the diversion program said, you need to do a course of counseling, or you need to do X, Y, and Z, and that was a requirement. If the person who was the subject of that decision didn't like it, felt that it was unfair, felt like for whatever reason it was, they were aggrieved by the decision, they have the ability to have it reviewed by a court under Rule 75. So what we've done here is added a subdivision B to the subdivision A that explains that prior to the filing of the complaint with the Judicial Bureau, someone who's aggrieved by the suspension imposed by the automatic suspension imposed by the commissioner may seek review of that suspension under Rule 75. So just a refresher of the process here. So the way this works is there is a complaint that is created, but it is withheld until they essentially know what the results of the YSAS program is. If someone failed out, then it gets filed. If someone fails to register, it gets filed in the Judicial Bureau. But if they complete it successfully, it gets deleted as if it never happened. So what this does is that before we get to the point where the Judicial Bureau is involved, if someone wants to have that automatic suspension reviewed, they have the ability to file in court to have that done. And the policy rationale that was discussed in the Senate about why to do that is that essentially what the previous process was is that there would be no recourse for someone that had an automatic suspension. So for instance, maybe there was bias at play, or there was some reason that the person felt that they should not have been issued that suspension. Previously, they had no option to contest that, but now they do prior to the Judicial Bureau getting involved. And then finally, you'll see some more of those internal cross-reference updates. That goes into subsection or section 2 of the bill, which is that report that the committee discussed previously. And then again, you'll see here in section 4 an update to the repeals that are in this bill. So you'll see subsection B, and we're on page 16 and 17. Subsection B was replaced with a repeal of 18 VSA 4230B. That's the civil violation for cannabis possession, which really mirrors this statute almost word for word, with the exception of the substance that's involved. So what you're doing is repealing this and rolling that in to 656. And then you'll see in subsection C, the delinquency is repealed and there is no more delinquency. There's no new process that's rolled in. Again, the policy discussion that was that occurred in the Senate is they wanted to treat cannabis possession like alcohol possession and not create that sort of dual track of a civil violation, but also delinquency, which there was testimony in both chambers about the confusion that caused some people. And so this was the policy choice and rationale of the Senate to put cannabis on the same footing as alcohol. And then subdivision or subsection D is the same as what subsection B was, just relettered. That is the extent of the changes between the two versions.
Any other questions?
Was there any discussion on the Senate side when putting in the cannabis about a DUI drug for treatment?
Can you elaborate a little? Or do you, what do you?
So like, we're using, I guess I don't really know what happens if a juvenile gets pulled over for impairment from cannabis driving. What's the?
Well, there's still the criminal penalties that are associated with impaired driving.
Yeah.
So that's a potential option.
Okay.
But again, since you're, that would be if you're underage, but not necessarily under 18.
Yeah.
Because under 18 is the family court delinquency. I'm paraphrasing a little bit.
Yeah.
And so really the criminal option would be available for the if you're over 18, under 21. But it would really just be the civil process now.
Yeah.
For those who are under 18.
Right. Because I could just see a question coming that's like, okay, so you've got the YSAS program for juveniles who possess alcohol and also for juveniles who are driving impaired by alcohol. And now we're adding possession of cannabis. What about driving while impaired by I guess that's like, so.
Yeah, I can't, and if memory serves, I don't think there was extensive, if any, discussion on that part, but if any of my colleagues has better memory than I do, I feel I welcome their.
Okay, yeah, I was just curious. Thank you.
Sorry, I mean, I have trouble getting or
Yeah.
whatever that is out there. This covers just alcohol and cannabis.
The statute itself, yes.
Why aren't we doing their any drug?
Policy choice.
Pardon?
Policy choice.
Not grabbing. Yeah. That's under the impaired driving statutes, correct?
Yeah.
They weren't covered previously, though.
I can speak to that briefly, if that helps. I think that these are just changes that have taken place, I mean, because alcohol is a substance is legal for people who are over age. But and now marijuana is the same. Those two get carved out and treated separately from all things that are illegal for everybody. And it doesn't change the laws around impaired driving. It was somebody pop for impaired driving or any of those. It just says the same way we've always treated alcohol different because alcohol's illegal for people who are under 21, but illegal for people who are under 21. Now marijuana's the same, we're treated the same.
Different but similar though with a prescription opiate or something. I mean, it's given to somebody lawfully, but then they're carrying or taking it deceptively to use it and then get caught driving. I don't know.
Well, actually has her hand up.
Anyway.
Well, if I may speak briefly to this point, currently there is a 0.02 violation, but that's a civil violation. And so this is changing it to refer it to YSAS. There's nothing comparable for other drugs or other substances as the civil violation. So any other driving under the influence of any other substance would be handled as a delinquency.
Through the court system.
It's just. I think that's part of the mistake here.
Yeah, that makes sense.
Yeah, that's good.
Sorry, Willa Farrell from the Attorney General's office. Sorry to interject.
And Marshall, would you mind for the people in
I'm sorry.
would you mind introducing yourself for the folks that might be able to hear over the lawnmower?
Sorry.
Thank you. Barbara.
So can you remind me or tell me, I'm not sure I do, is the difference between somebody who provides cannabis to a minor, the charge the same as for providing alcohol to a minor?
I don't know. I don't think so. I think that there is an enhanced charge though for distributing cannabis, but I would defer to my.
But so I'm interested, I'm curious, I mean, I'm curious if the Senate didn't have a discussion about that. I think,
They
I'm not sure.
didn't really go much outside the four corners of the
Yeah,
bill.
Okay, they just,
They just discussed cannabis being included. Yeah. But I would defer to Department of State's attorneys or the Defender General as far as how those two violations are treated differently.
Ian?
And I think, so just to clarify off of Will's point, so I think where I got confused was this, there's a civil violation. I forgot there's like the civil violation for juveniles on a 0.02 or above.
Correct.
And we moved that, and there's no like equivalent for drug DUIs for juveniles because I don't know why, but like, so there's nothing to move over here.
Correct.
That's
Yeah. Sorry for failing to refresh.
No, it was on me. I just couldn't really, I was trying to remember how this sort of what the dance was and now.
Now that we have the mambo steps together.
Yeah.
Are there any other questions? If not, we'll move
Just one
to
more
our
time.
witness.
Just one more time, there's alcohol, the alcohol offense is more than cannabis? Is that what I heard?
What do you mean?
Whatever Ian just said, that go and,
So there's a 0.02 civil violation for underage driving while you're intoxicated. There is no
with either alcohol or cannabis.
just with alcohol, because there's no 0.02 BAC equivalent
Okay,
for cannabis.
okay.
So that's why there really wasn't much discussion about that aspect.
Okay.
Maybe one of the reasons.
Because remember when we originally did the original cannabis legislation, there is, and to this day, there still is no way to test it. So there's no equivalency chemically, you know, and therein lies the dilemma. Anyways, unless there's any other questions, we'll start with Terry Corzone from State Court and the Vermont Administrator. Hi.
Hi, thank you very much. Sharon Corson, State Board Administrator. And my comment regarding H105 will be limited to just what role this State Board Administrator's Office has vis-a-vis the implementation of the new provisions. And the first one is the new section 1C on page 8, which has to do with issuance of a notice of violation. There's to be a form approved by the court administrator. We have a notice of violation form already in terms of the possession and procurement aspects of it. So what we'll be doing is modifying that notice of violation form to accommodate the new criteria and provisions in H105. So that should be very, very doable. The provision about a person shall not be cited for more than one violation of subsection B arising out of the same incident. On the notice of violation form, there's several, depending upon the different potential violations. So our assumption is that the law enforcement officer who would be completing this notice of violation would select whichever one of those would apply. That would be kind of just to point that out and make that comment regarding that. And the next provision that impacts the Court Administrator's Office is an issuance of a notice of suspension. And that's a new section 1D on page 9. We would be creating that form, a new notice of suspension form, but we'll be patterning it after the notice of intention to suspend form now, just the general one. So we can modify that and include again the different requirements that are included on the form that are spelled out in the statute. With the effective date of July 1, 2025, we don't anticipate any issues with modifying the notice of violation form or creating the notice of suspension form that is spelled out here. The next provision has to do with the annual report that the Attorney General's Office is required to provide, and that's in new section 1J on page 15. The Attorney General's Office is to annually provide a report beginning October 1, 2026. And there's one of the aspects of the data points that would impact us, and that's the number of persons who serve suspensions imposed by the Judicial Bureau if they fail the program. So we can create a code to delineate that data point and then provide that. Should be no problem to provide that to the Attorney General's Office. Otherwise, the data points in the report, Willa has indicated that they have the ability to gather that information. It mostly has to do with people in the program and different criteria for them. And there's one other addition. Ben made reference to it previously regarding an additional level of review that's been added. And it's my understanding that Judge Zone, who will be talking about H105 from the judge's perspective, is going to address that.
Okay.
So those are the comments that I've had just in terms of our ability and willingness to prepare the forms by the due date and contribute to the annual report.
Question?
Okay,
Thank you, Chair.
Sure.
Thank you, Jim.
And Judge Zone is participating remotely.
Yes,
coach.
yes.
Okay. Thank you for the opportunity to come there.
Thank you. And our next witness is Superior Judge.
Good afternoon, Tom Zone, Chief Superior Judge. Representative Rachelson, under 18 VSA 4230 subsection G, the penalty for supplying cannabis to someone under 18 is up to 2 years, up to a $2,000 fine. Under 7 VSA section 758, it's a fine of between $500 and $2,000 and up to 2 years. So it's very similar maximum punishments.
Thank you.
So as far as H105 goes, the definitions have been added and that we think that benefits the bill. The discussion that we tried to start over in the Senate was that we think that it would be helpful to have an entirely new structure of how the bill is put together. And that means you would have definitions up front, followed by offenses, followed by notices, the ticket, the registration and YSAP, notice to diversion. In other words, we think that it would be a better structure to have it spelled out in a different format, that the way it currently is, it could be confusing. That being said, I think Ben said it best when he said, at this stage in the legislative process, we recognize that that's unrealistic. And so that would be something that we would certainly work with Leg Council and the legislature on in the future, if that's the direction you would like to go next session. The one big change in this bill is that prior to the Senate adding that language about Rule 75, the way this worked is a police officer gives a youth a ticket. That ticket, after 11 days, means that youth loses their license for 90 days. There was no hearing, no remedy, it's gone. If the youth completes the diversion program, they still have suffered that 90-day loss, but they don't go to court with the ticket. If they don't complete YSAP, what would then have happened is the ticket, as Ben said, is filed with the court. And if they lose in court, they can have a fine. And if they lose, their suspension goes up to, I believe, 180 days. And so at that point, they get a right to contest it. And so that's a policy decision for the legislature. I would note that currently in DUI law, the way it works for what we call a civil suspension hearing is that when an officer stops an individual, and let's say they had a 0.10 breath test, the officer would give them a notice of intention to suspend. That form, specifically under 23 VSA section 1205, tells the individual that they have a right to request a hearing within 7 days. The form lets them know where and how to request that hearing. It tells them the date and time of that hearing right on that form, so they know when they're going to court. If they don't request that hearing, the form clearly explains to them that 11 days from the date they receive the notice, they will lose their license. And if they do request the hearing, their license does not get suspended for a DUI Civil 1, a first offense, after 11 days. What has to happen is that hearing is held within 21 days. And at that hearing, the court would then set what's called a final hearing within 21 days of that. And so from the time of the initial stop until the time of the hearing, it's 42 days. If you have a prior DUI civil and it's your second or subsequent offense, what happens is you still have that form, but after 11 days, even before that preliminary hearing, your license is suspended. And then if you go to court at the preliminary hearing and then have the final hearing and you're successful, then you would have that suspension vacated. The difference in this situation is that there is no hearing being set. And so, again, previously, the youth would have not known what to do. They'd lose their license. And as Ben mentioned, if the officer simply made an honest mistake, if the officer had a bias or prejudice against the individual or a group of individuals, there was no remedy that the legislature was providing for them to address that first 90-day suspension. And so what the Senate did, instead of creating an entire new section in this bill that would look like 1205, and let me be clear, that would take a lot of creation because you'd have to decide, where do the hearings live? How far out are they? And so that's not something that I think can reasonably be done at this stage of the game. But what now has been put in is at least something that lets it be very clear for individuals that if this happens to you, you have the right to file under Rule 75 in the Civil Division of the Superior Court a proceeding to challenge the suspension. Again, is that the same as the 1205? No. It's a different process. Individuals may not have the knowledge and experience on how to do it, but at least to put something there, and the notice that Ms. Corsone's talked about, make sure that it's clear to the individuals what their rights are. And that's about all.
Questions for Judge Zoner? Yes.
Reflexive, like, so Judge Zoning, I just, again, to make sure I'm understanding your comments about this part specifically, it sounds like you're saying there would be a way to do this a little bit better, there's a better way, but that you wouldn't recommend we try that now. But again, if you're potentially suggesting that we reorder the entire statute at a later date, we could revisit this issue that you're bringing up now. Is that fair?
That's fair. If you want to adjourn the session in the next few weeks, you would not have time to do this and get it in a way that would be more similar to 1205 for the suspension process, and also to have it in a different structure for the underlying bill itself.
Right. And do you, so for future reference, do you recommend the structure in 1205? That's what I'm not sure. Like, if we are going to.
That's a policy decision for the legislature.
I know, but I wouldn't, we need hints sometimes.
The question for the legislature is a very simple one. Do you want a process that says you have a right to a hearing if you go and request it in a different court under Rule 75, which requires following the rules of civil procedure, and there's a lot of steps that you might have to take there? Or do you want a procedure that you spell out in one statute that is very similar to the 1205 statute for civil suspension? I would imagine that the latter of those two is a format that would be used by more individuals and provide a greater ability of the individuals who received those tickets to have them reviewed in a court.
Okay, thank you.
Other questions? So our next, thank you, Judge Zoning.
Thank you. Have a great day, everyone.
Our next witness is Willa Farrell. It's court diversion.
Afternoon, Willa Farrell, Attorney General's Office, Court Diversion and Pretrial Services. My comments are brief. I appreciate the changes that the Senate made to H105. The most substantive as it relates to the program is the addition of the cannabis possession. And I think that is a logical and change that would align with, frankly, current practice and how programs work with youth holistically around substance use and not parsing out individual substances. So I that's the focus of my comments, is really that I support that addition, and the other changes as I've followed along make sense and agree to. Short and sweet. In the spirit of the day.
Questions? Well, thank you very much. And I hope you had an enjoyable walk upstairs.
Yes, it was a treat to be outside for 5 minutes.
Thanks for the time. And our next witness is Lisa Pepe. Are you with us?
Yes. Hello. Good afternoon. My name is Lisa Pepe, and I am a Youth Restorative Services Coordinator at the Burlington Community Justice Center. Thank you for inviting me to speak today. So I've been working with youth in the court diversion program since 2019, first in Franklin County and now here in Chittenden County. My role has included that of a case manager for the Youth Substance Awareness Safety Program, which I will be referring to as YSASP throughout this testimony. After reviewing previous testimony provided to the House, I am in agreement that the expansion of age eligibility for YSASP as a whole would be a positive change. That being said, in this testimony, I would like to focus primarily on the addition of cannabis. So I feel that opening the eligibility age of cannabis referrals to the YSASP program would assist in streamlining the process for all youth, so we can take immediate steps in order to ensure that the youth is receiving the best care in a timely fashion. Currently, youth ages 16 to 20 who receive a possession of cannabis citation are referred to the YSASP program by the officer issuing the citation, whereas youth under 16 receive a delinquent charge and are sent to court. In our county, that ultimately ends up being referred to the diversion program, which comes to our office anyway. Generally, youth who come to us through YSASP or through court diversion receive the same services. They complete a screening regarding their substance use, followed by a meeting with a YSASP or diversion coordinator. During that meeting, they discuss the screening results, frequency of use, reasons for using, risks, impacts, etc. They then look at next steps with the coordinator. One major difference between the two programs is that in the YSASP program, the coordinator is able to attach completion of a substance use evaluation, often followed by counseling by a licensed professional. If the youth is referred through the court diversion process but has high risk of current or future substance use, the youth has to be fully in agreement about engaging with an assessment. I believe this is an important factor in the process when it comes to cannabis use, as from my observations, youth tend to use cannabis on a more frequent basis. For example, many of the youth who come through our program for cannabis use are using cannabis daily or several times during the week. This shows a pattern of use that could lead to addiction, and it is crucial to have the ability to intervene at the beginning stages of a youth's cannabis use. If a citation comes through YSASP, we are usually able to address this in a matter of weeks versus the months that it may take for us to receive a court diversion referral. As stated in my testimony to the Senate, I had a client who was over 16 who was referred through YSASP. They made meaningful changes in their substance use habits and were able to close their case in approximately 2 months. Conversely, I had a youth under the age of 16 who was referred to diversion, and it took 8 months to close the case out because as time went on, communication with the family became more challenging. I feel that expanding the age of eligibility for YSASP would be an easier path for law enforcement, as they often refer youth to YSASP when they have not met the eligibility requirement around age, which requires us to reach out to the officer, have them void the ticket, and then file a delinquent charge. When this is the case, one of two things often happens. It takes more time to receive a referral to court diversion, so the process is lengthier, and we do not have the opportunity for that early intervention. Or the officer voids the ticket and does not file a delinquent charge, resulting in the youth receiving no services at all. I feel that the most efficient and productive way for a youth under 16 years old to receive services around cannabis use would be for them to engage through the YSASP program. Rather than waiting months for services, we could intervene early to engage them in important conversations, and we could do this without the fear of a delinquent charge. Our YSASP program educates youth on the dangers of cannabis use, along with exploring risks and impacts specific to their situation. Youth in YSASP are often surprised by the risks they learn about that are associated with cannabis use and are generally enthusiastic about creating a plan to decrease their use. In my experience, youth in court diversion tend to see it more as a punishment due to the delinquent charge and are more resistant to change. The ability to engage these youth at a young age in a swift manner increases the chances of youth receiving education and intervention to assist them in making informed decisions around cannabis use. Thank you again for your time.
Questions for Lisa? Yes.
I don't know if it's the background noise or whatever, but I'm gonna ask you the same thing. I just want to make sure I'm understanding that you're saying this change, YSAS, it allows a faster route to intervention or a faster intervention for youth under 16. So you support this change.
Yes.
All right, thank you.
Angela just summarized.
It's not you, it's me.
It's that cut to the chase. Any other questions, Lisa?
Thank you.
Thank you very much.
Lisa, thank you so much. And thanks for your work.
Of course. Thank you so much.
And next on our list is Marshall Paul from the Defender General's office.
Thanks very much. Marshall Paul from the Office of the Defender General. I will try to keep our testimony pretty brief. We supported this bill when it left the House. There's been what look like pretty substantial changes made, but they're honestly not that substantial. Really bringing in the definitions section makes it look like a lot of change where there isn't a lot of change. So we support the changes that have been made. We support incorporating the definitions in there. We also support the changes that allow for some mechanism for there to be essentially a civil suspension hearing of some sort for young people who want to avail themselves of that. Frankly, we don't have much to say beyond that. We support it for the same reasons that we supported it when it was in here, which is that we think that the distinction of treating young people under the age of 16 differently than young people over the age of 16 didn't make a lot of sense. And then with the changes in the Senate, which said, you know what, it also doesn't make a lot of sense to treat those same young people differently, whether they're caught with marijuana or with alcohol, we think also makes sense. In fact, a lot of the cases that we see are kids who get caught with both alcohol and marijuana at once. And weirdly, they get treated in two different ways for what was really the same, it's two different substances, but the same offense needing the same kind of treatment. And so from our perspective, these changes really help to just sort of consolidate all that and put all of it into the place where it belongs, which is in the YSAS program. So we're supportive of that. And to sort of address the question about what about other drugs, we do think that it is appropriate to keep it the way that it is, where this is about marijuana and alcohol. That's what the YSAS program is designed to address. And it is actually from a, I don't want to say that it's okay for youth to be using substances, but in terms of what is normative teenage, adolescent substance use, we do see that it is pretty typical that teenagers are engaging in some level of marijuana and alcohol use. It is a lot less typical and a lot more concerning when you see other harder drugs involved in that, when you see teenagers using opioids. And those are cases that we wouldn't want to steer through sort of the YSAS program. Those we would want a much more sort of intensive engagement from DCF and the kinds of probation and treatment services that can be provided through that court system if we're talking about those more serious drugs. When we're talking about alcohol and cannabis. Most often, really the right approach to intervene in adolescent use really is education. Really, it is to step in and say, I know all your friends are doing this. I know it seems like this is okay to do. Here's why this is in fact not okay to do. And that's usually actually the most successful way to intervene with kids with those types of problems. When it's kids who are using opioids or something else, yeah, you need something much more heavy duty, a much more intensive intervention. And that's why I think it's really appropriate to have this program for underage drug and alcohol use, but not to include other drugs in it.
Yeah,
So you're okay with the RCP 75 being the appeal opportunity?
Yes, I think that maybe in the future, depending on how much Rule 75s get used as a means of challenging a juvenile civil suspension, it may turn into something. Anytime Rule 75 gets used for the same thing more than a few times, then eventually we create a new procedure for that thing. Because Rule 75 is kind of a very flexible mechanism that basically allows anybody to challenge any government action or inaction that has aggrieved them. So it's very flexible and it can apply to a lot of circumstances, but it's also not very, if you're going to apply it to the same circumstance over and over again, you may just as well have sort of a crafted procedure for that. So I think we'll probably wait and see how many cases come up. In the past, we haven't had the ability to challenge a juvenile civil suspension. And we haven't come to a lot of cases where we've been like, man, we really wish we could challenge the civil suspension here. So my guess is, and I'm just speculating, that these Rule 75s are going to come up infrequently. And therefore there probably won't be a real urgent need to design something more specialized to the docket. But maybe I'll be wrong, and it'll turn out that in the first year, we'll get a whole lot of these Rule 75s, and we'll be back here next year saying, hey, we've really got to craft a specialized procedure for juveniles to challenge civil suspensions, something more akin to the adult civil suspension procedure.
Yeah.
But my guess is it's going to happen a few times a year, and it won't be worth crafting a new procedure just for that.
Okay, that's really helpful. Thank you.
and so the work that is expected under the measures and report section 2, will hopefully deliver that data that we're looking for in collaboration, it says in collaboration with the Attorney General and the Vermont Statistical Analysis Center and others as needed to do the outcome measures. So hopefully when we see that report, that will trigger at least the review of the data, then we can make a policy decision after. And that gets to what Ian's referring to, I think.
Yes, and I think it might be implicit in section 2, but one thing I'm just noticing and reading through section 2, one piece of data that I haven't been able to find, and I was looking for it in preparation for my testimony here and in the Senate and couldn't find it, and maybe could be added to section 2 in the sort of data gathering part, would just be some data on youth DUIs in general. How many of them do we have? What substances are involved in them? Because I'm curious about the question that Representative Olson asked about other substances. I don't actually know how often we're having youth who are charged with DUIs where there's substances other than marijuana or alcohol involved. I'm sure there must be some. I don't know how prevalent it is. I know that marijuana and alcohol make up the vast majority of our youth DUI cases. I haven't actually represented a young person charged with a DUI who's been found to have any substance other than alcohol or marijuana, but I'm curious how much that happens, and that kind of information I think would be really useful to be gathered in that section 2 committee.
So I guess question for Ledge Council would be would it be necessary for us to, at this late hour, to propose an amendment or just a guiding letter, requesting additional data?
Paul, it's your decision. Memory serves, I think the process, I think you get one more shot at the apples. I think. But
With, at this state, you know, in time, we're trying to reduce the number of shots at the apple.
Thank you.
Yes.
I think what I've heard is that we are on a very tight timeline, so.
Oh, yeah.
Going back and forth, but I think it is something, so we always can, but I would say that it's also that we have next session that we could add on to it.
to answer the other part of your question, you could write a letter to the entities responsible for that report, just suggest that they don't that is an option that wouldn't have the legislative process attached to it.
You know, it will just be a little more clarification okay. So I think that would get to that question, hopefully, help us all, because your point's well taken, Tom, and then yours as well, around, what's the data that supports it and what might support expansion or contraction. So that would make sense. Any other questions? Yes.
I was gonna say, Marsha, we had been happy to see, I texted somebody to ask if we had data on minors charging DUI. I had asked for data regarding the current statute and consumption or procurement. Since July 1 of 2024, consumption of alcoholic beverages by minors are 142 cases. Minors misrepresenting age to procure alcoholic beverages, 12 cases. Possessing alcoholic beverages, possessing 18 cases. So 172 total under that correct from therapy and possession.
And when was that since? What was the?
July 1, 2024 through.
All right. Gotcha.
Big issue, so a little less than a year. That's.
So that data lake that we've been exposed to in the last few years is full, or I should say is rich with
We'll see though, because between now and July 1, I think is sort of peak. That's peak adolescent drinking season, so I think that data is missing sort of a key component.
Key
that-
2 months.
that graduation through the end of school was a little bit trouble.
it's prime fishing season
We always,
on that fish metaphor.
we always find in juvenile court, it's graduation season and county fairs are like, you can guarantee yourself.
Oh, yeah.
Always like,
Prom time, and all of that.
I always thought such a big deal. They're doing a real good job with all like keeping kids from drinking at prom activities these days. We always expect prom busts, but we don't get those. It's graduation season.
Yeah, still up to them. Thank you. And our last candidate is Kim. You have the comp.
I like it on this.
Sorry. Well, it must have been the walk over in the sun.
I think so. The backlighting.
Yeah, right.
was good. Okay, perfect.
This font of now.
Good afternoon, Kim McManus, Department of State's Attorneys and Sheriffs. We have very few comments, though I do want to make hopefully a clarification for some of the questions and comments from earlier. We supported this bill when it was in the House. In the Senate, when cannabis was added,
we essentially were neutral on it. It's a policy call as testified. The practice is that folks with the possession of an ounce or less, regardless of their age, eventually are going to diversion and YSAS or going right to YSAS. So going right to YSAS for the education reason makes sense. What's really important to remember though is if a youth has other things going on, right? Like, so if there's other regulated drugs are involved with cannabis, this does not prevent the state from bringing delinquency charges. Same with the driving piece. Very important to remember that this is if a juvenile 12 and up, if their blood alcohol is 0.02 or higher, but there's no signs of impairment of driving. So if there are signs of impairment, if 13-year-old's taking a joyride after having a beer or two and is leaving all over the road, that is under Title 23 and will proceed under the influence. Now, there may also be a civil violation, but either way, we're going to be addressing the under the influence part. This piece is that if a 13-year-old's driving a car, more than likely that car is being pulled over, and if the BAC is noted, then that's a massive education issue. We haven't seen a driving under the influence issue maybe, but this child has had some alcohol to have that blood alcohol content. And that I think is precisely the point of why SES wants those children in their program right away. And we support that. So I just wanted to alleviate any concerns there might have been around the table that this somehow does not address driving under the influence. This does not in any way take that out of the state's ability to address those issues. But otherwise, we had no issues with the changes on this side of things.
Questions for clarity? Something brewing?
Thank you.
I hope you enjoyed your.
Always, every time.
Rain, snow, or shine.
Well, the sun's always at her back coming across.
Is that all the witnesses?
Yes, we have reviewed in entirety.
Coach is really
Much more
efficient.
efficient than.
He is. He runs a tight ship.
Was there any concerns or should we get a motion to concur?
I think we could probably have a motion to concur, and if there are any, if there's any further discussion, we could have that before the final.
I'll take a motion to concur with the Senate proposal of amendment to H105. So moved.
Second.
Further discussion? Yes, Ian.
I was close. Yeah, go ahead.
We heard some testimony today about potential more significant reworking of this entire statute, which is going to take more time than we have. And it sounds like the state where this is going to if we do pass it, the state it's going to be in, while it's not perfect, it seems like it's better to move forward like this. And then if we think it makes sense to come back and rework it, then we can. Nothing stops us from doing that. And I think hearing from the Defender General's office on the Vermont Rules Civil Procedure Rule 75 appeal process for the automatic suspension for juveniles being sufficient makes me feel a lot more comfortable moving forward and voting in favor. Anybody else?
I just have concerns about potentially expanding the program in the future. I mean, we talk about legalizing other compounds and substances over the counter, psilocybin, things like that, and that could also become a reality. And I think that the possibility at that point, some of these drugs far more dangerous than some of the others. I'm just getting concerned, but we do need the interview. I agree with that. We have backup for that, but it's just something to consider. It seems a little clunky on the civil side, but we'll figure it out. Funky. Oh, poor funky, yeah.
Mr. Chair, I think that, you know, I would agree with Tom, and with this caveat that one of the things that we've come to understand, you know, as this growing change in legalizing other substances does occur, you know, each one has its own you know, unique subject that it brings. And, you know, so far, you know, we've hopefully had a pretty good clinical understanding of what's going on. So hopefully we will continue approaching those in that manner, and we'll do it on a case by case, you know, basis.
Right. Anybody else? Okay, seeing none, all those in favor of concurring with Senate proposal amendment to H 105, raise your hand. Opposed, it's 902. All right, so I have nothing on the calendar for tomorrow unless well, we may be getting S 109 back. I don't know when. Maybe we'll have a walkthrough. Maybe we'll walk through in the afternoon of S 109, which will essentially be, here are the parts they took out in the Senate.
I think that's moving.
So it should be on the floor tomorrow.
They unordered it to one?
Yeah, they'll have to spend.
Done resting.
Exciting little development.
Yeah, so at some point we'll have to take a look at that and have a, but that may not be tomorrow. But I do have it is 9 o'clock on Thursday. Some students from Dartmouth are coming in to go over the findings of their semester-long project. What the heck is it called? I feel like I'm not being competent right. Oh, that's a competency. Competency restoration. I needed my competency restored right there for a second. See how that worked? Anyway, so yeah, so that is on Thursday at 9, but that's the only thing I've scheduled other than that we have to walk through one of them. I think that's probably. So, all right. So we will adjourn until further notice, because I'll try to get 109 at some point tomorrow, but not at 9.